So I'm going to start off this afternoon by talking to you about some of the challenges that families face when they have a missing loved one, some of the practical challenges, the legal solutions and the gaps in the law that there are preventing families being able to manage the property and affairs of a missing loved one. I'll then pass to Sarah, who'll talk to you more about the Presumption of Death Act and how that can help families who need to resolve a missing loved one's affairs if they're believed to have died. And then finally Patricia, who's going to speak to us about the government's proposals to introduce a power of guardianship to allow families to manage and protect a missing loved one's affairs while they're missing.
And Susanna, how many families are likely to be affected each year?
So we know that around 1,000 people are missing for longer than a year. Each year that happens, and 1,000 more missing incidents last for longer than a year. Not all of those people will have property and affairs that need to be managed or resolved over time. However, we think there's several hundred families in this situation every year, and that's cumulative because people often remain missing for many, many years. So the numbers are small but not insignificant in terms of the national picture. And these challenges that they face are so immense that it feels incredibly important to sort them out, as you know.
You can make an application at any point after the disappearance as long as the person is thought to have died, or if they've not known to be alive for at least 7 years. In my experience, the shorter the period of the disappearance, the more important it is that the evidence provided is fairly comprehensive and detailed. You have to establish to the court on the balance of probabilities that the missing person has died. On domicile, the missing person has to have been domiciled or habitually resident in England and Wales for 12 months before the date of their disappearance, or alternatively, if the applicant is the spouse or the civil partner, they have to have been domiciled or habitually resident for that 12-month period. Sometimes I get asked, is it a problem if the missing person went missing abroad? And the answer is no, it isn't a problem, but you have to address the issue of domicile.
Sarah, you said you were involved in 4 cases at the moment. How many cases have you been involved in overall since the Act came into force?
Since the Act came into force, probably about 6 or 7, and then before that, under the Leave to Swear death order, probably about another 7 or 8 cases. So it's a relatively new Act, so there's relatively few applications being made. So I'm not speaking from the pedestal of huge experience, but I like to think that I have acquired some experience of what's needed and work closely with the district judges locally to find out what their needs are and what they think is required.
So this looks at some of the key features of what is proposed in the consultation and in the government's response to that consultation. And as a start, we're looking at when can you apply to be a guardian. So the proposals say that the person has to be missing for 90 days before you can make an application for a guardianship order.
So what if something urgent crops up before those 90 days, Patricia?
That is a good question, and the consultation doesn't make provision for this, but in the response, obviously somebody must have raised this when responding to the consultation. So the government has said it will look again at what it can do, what provision it can make if an emergency or an urgent matter is required. I think we would be hopeful to see these proposals brought forward in a bill within the next year or 2 years, though it may then be a little more time before guidance is issued by the OPG, further practice directions are drafted before it can actually be brought into effect.
Absolutely.